This conference will now be recorded.
Hello and welcome to today's GRN webinar. Thank you for joining us and we're very much looking forward to hearing from our speaker with his work visa legal update. First of all, for those who don't know me, my name's Dan Hawes and I'm the GRB Group co-founder. This was something I set up with a colleague back in 1997 after we both graduated in business studies from Brighton University. The GRB Group, as we've become to be known, have grown now to become the go-to platform for high caliber university students, recent graduates, alumni and employers. We have over 48 staff based in our office in Brighton, where I'm coming to you today. And we've supplied over 2,000 clients across all sectors, companies you'll definitely have heard of like Amazon, IBM, Unilever and Ocado, to name but a few, but several fast-growing SMEs as well. Our recruitment experts have successfully matched over 8,000 graduates with full-time graduate or executive level jobs. So a quick overview about the GRB Group before we get into the GRN. So Graduate Recruitment Bureau is a search and selection recruitment consultancy, multi-divisions, supplying graduates all over the UK. We also have two experienced hire divisions. One's called Cortex, one's called Metrica. So for those companies who are looking for graduates with up to 5 years experience in IT or analytical skill sets. We also launched Graduate Mentor. This was a new initiative that we'd had the idea for about 5 years, but we decided to launch about a year ago to help disadvantaged, underrepresented and diverse groups of graduates have free one-to-one mentoring sessions. We have over 200 volunteers and we've had over 600 mentoring sessions with lots of success stories. So if you're interested in becoming a mentor, do drop me a line after the webinar. We also have a variety of other initiatives. Student Diaries is a monthly podcast, so that gives you an opportunity to hear from 3 students once a month, find out what it's like to be a student right now. We also manage several LinkedIn groups, for which we have one for GRN, which I hope you've all had access to recently to find out about this event and other speakers and events. We also have Rising Stars. This is our showcase of 50 final year students who will graduate next summer that we give you an opportunity to get in with very, very early, have a look at their CVs and perhaps arrange interviews. That's called Rising Stars. We also help students who are looking to set up their own business, an initiative called Student Startup. And GRN. GRN was set up by GRB back in 2009. Now, originally, this was for our clients. We've extended invitations to other organisations who've shown an interest and also friends of our business over the years. So various stakeholders, usually university careers people and other freelancers and other people involved in the world of graduate recruitment. So essentially not much really happens in graduate recruitment without us knowing about it. And the aim of GRN is to bring together HR advisors, HRBP people, recruitment directors and early talent leads with the idea to discuss current topics, of which we've covered many over the years, presented by a mix of relevant and influential speakers. So the idea is that members are able to share best practice in a confidential environment, enhance their learning, and ultimately help them become better graduate recruiters and have a better understanding of early talent. Now, we have had a huge number of new members join us, and many of them are along today, so welcome to you. At the moment, we have over 3,122 members, which is absolutely brilliant, covering a broad range of organisations all over the UK, and many of you have come along today for what is turning out to be a record attendance. So we've got obviously a very important subject that you're all keen to find out about. So our members tend to be from FTSE 100 firms, but also a huge number of other early talent recruiters who are fast-growing SMEs. But generally, they cover most sectors and there's a nice representation of different sectors along today. So as a member, you receive invites to these webinars, other special events, which we hope to host in person, maybe next year. You also have access to the LinkedIn forum. There's lots of debate and the opportunity to find out about news, events, surveys, and also jobs in our sector. Plus, we put together a quarterly newsletter with an interesting roundup of news that we hear about and that we can email to you. Now, if you are interested in being a VIP member, there are extra benefits. Do let me know at the end of the seminar. So in the meantime, if everyone can make sure they are on mute, their videos turned off so there's no interruption, that would be wonderful. The session will be recorded, so if you do have to duck out or you'd like to go back through this presentation, I will email you a link to our YouTube channel and you'll be able to listen back to this recording. The slides will also be available in PDF format, so if you would like a copy, please let me know. So just to give you an idea about who's in the room, because you know in these virtual events, it's not always immediate who else is with you. So I did a quick word cloud here of all the job titles of everyone who's registered to come along, and front and center you can see most of you are either early talent managers or involved in graduate recruitment in one shape or form. So you know, a variety of different levels of seniority, but you all share one thing in common. You're all involved with early talent. So let's crack on. The agenda. In a short while, I'm going to be introducing you to our brilliant speaker, Dipesh Shah. Now, he's a corporate immigration partner at JMW Solicitors, who have actually presented before. And so we're very, very keen to have them back on the platform to share with you their work visa legal update. Now, as always, there will be the opportunity to have your questions answered, and there is the chat box, which you should be able to access. I'll be monitoring that throughout the presentation, and I'll be picking off various questions at the end and put them to our speaker for around 10 or 20 minutes. There will be the opportunity, if you would like, on our LinkedIn forum. So if you don't get the opportunity or you think of something after the event, please visit the GRN LinkedIn forum, as Dipesh will be available on there for 24 hours after this event. So we're going to aim to finish at 1:30. You're all very busy people, and you're all very interested to kind of get an overview of some of the changes that have been happening. So we aim to have this webinar completed within the hour. So Dipesh is a corporate immigration partner at JMW Solicitors. A fantastic experience over 13 years, providing advice and assistance on applications ranging from Tier 2 skilled work visas, investor visa applications, sole representative and innovator visas, to all manner of personal immigration matters. He regularly assists HNW and UHNWs, CEOs and senior executives of multinational firms, large and SME corporates, private and corporate banks, leading fashion, music and sports stars, foreign diplomats and members of nobility in seeking entry and residence in the UK. So we're delighted to have Dipesh with us today. I'm going to make Dipesh the presenter, and he'll be able to share his slides with you and explain what's going on. Now quickly scroll to Dipesh. There we are. So Dipesh, over to you when you're ready.
I am. Sorry, I'm just waiting for the connection. Why is it not going? Oh, God. So, sorry about that, Dan.
All right, Dipesh, no probs.
Right, okay.
Over to you.
Good afternoon. So the world has changed with the withdrawal of the United Kingdom from the EU on the 31st of December 2020. For the first time in over 30 years, EU citizens will be considered on an equal footing to immigrants from outside the bloc as part of the move towards the UK's new points-based immigration system. Good afternoon, ladies and gentlemen. My name is Dipesh Shah, and I head up our corporate immigration team at JMW Solicitors. Thank you all for attending this GRN webinar on the new immigration rules with effect from the 1st of January 2021 and the new right to work requirements with effect from July of 2021. On the 19th of February 2020, Home Secretary Priti Patel announced a significant change to the immigration rules, designed to shift the economy away from relying on cheap labour from Europe towards a high-skilled, high-wage, high-productivity future. A move by the UK government to press ahead with its plan for a new post-Brexit points-based immigration system was slammed by critics as out of date, with the economic realities exposed by the coronavirus pandemic. Speaking in the House of Lords, Ms. Patel admitted since publishing the details of our new points-based system in February, our world has undoubtedly changed. Many companies already have grave concerns about how this will impact their business, from the additional costs to the new visa requirements and the ability of their prospective employees to qualify in light of the new English language requirements for EEA nationals. Together, we will try and dispel some of the myths, questions surrounding these changes to ensure you and the companies you work with are fully equipped to recruit foreign workers under the new immigration rules. So, in light of the fact that the UK government have written into law that it was committed not to seek an extension of the transitional period, a simple points-based system was introduced on the 1st of January 2021, with further reforms scheduled to be implemented at a later date in 2021. There are, however, significant omissions from the proposals, a route for lower skilled workers and one for self-employed persons. For the first time since the introduction of free movement regulations, EU nationals will have to provide proof of a job offer in the UK, and employers will need to hold an approved Home Office sponsor licence in order to recruit foreign talent from outside of the United Kingdom. The sponsor licence is valid for a 4-year period and provides access to an online sponsor management system through which employers will be able to issue a certificate of sponsorship to their respective candidates, who will then in turn use this certificate to apply for their skilled worker visa. The sponsor is responsible for ensuring the migrant has the necessary points to qualify under this tier, and sponsors will have an ongoing compliance and reporting obligation after a COS has been issued. An overview of the process is that obviously that we apply using an online application process for a sponsor license, and we have to provide a minimum of 4 documents to evidence that you're a genuine UK entity. You have to ensure that you have the correct mechanisms in place to monitor your staff, and applications need to be sent to the UKVI with a signed submission sheet 5 working days from submitting online. Applications are then processed by UKVI within 8 weeks or 10 days under a priority service. As you can see from the slide, there is a number of duties and obligations on employers in order to comply with their sponsor license. These can be things such as record keeping, compliance with immigration rules. There are also additional requirements for skilled worker duties. You have to obviously make sure that you cooperate with the Home Office in full, and reporting requirements and penalties for non-compliance. One of the main questions we always obviously have is whether an employment agency can apply for a sponsor license. So the simple answer to this question is no under the Immigration Act 2016. As part of the Home Office sponsor license requirements, the organisation sponsoring the candidate must do so for the purpose of the candidate filling a vacant position with that organisation. There are no provisions that allow an employment business to sponsor a candidate purely for the purpose of supplying that candidate as labour to another organisation. This is largely because the sponsor must be responsible for directing the work done as well as paying the candidate. The Home Office, within their sponsor licence guidance, specifically addressed this issue in sections 5.6 and 5.8, which states as follows. If you're an employment agency, you can apply for a sponsor licence, but only to sponsor migrant workers who will be directly employed by you in connection with the running of your business. You cannot sponsor a migrant if you will then supply them as labour to another organisation, regardless of any genuine contractual agreement between the parties involved. Clause 5.7 further states that if you're an employment agency or intermediary and we grant a sponsor license to you on this basis, but later find out that the migrants you were sponsoring have been supplied as labour to another organisation, we will revoke your license. Furthermore, Clause 5.8 states that if you're a sponsor that wants to employ a migrant worker who has been supplied to you by an employment agency or intermediary, you can only assign a certificate of sponsorship to the migrant if you have genuine responsibility for deciding all the duties, functions and outcomes or outputs the job the migrant is doing. And furthermore, that you're responsible for agreeing and paying the migrant's salary. Now, in terms, obviously, a brief overview of the skilled worker application. So now that you've obtained a sponsor license, the next step is to prepare the prospective candidate's skilled worker application. As a result of immigration rule changes with effect from the 1st of January 2021, there have been a number of welcome changes to the skilled worker category. Anyone wanting to come into the UK to work must have a job offer with a salary threshold of $25,600. Though a salary floor of $20,480 will be accepted in special cases where there might be a shortage, such as in nursing. The skills threshold for foreign nationals wanting to work in the UK are being lowered from degree level to A level or their equivalent. Furthermore, the cap on the number of skilled workers has been scrapped, and the requirement to conduct a specific resident labour market test has also been removed, although employers will still need to evidence that the role is for a genuine vacancy. Employers will also have to pay an immigration skills surcharge of up to £1,000 a year for each migrant they employ, while incoming workers will face a £624 immigration health surcharge to cover possible use of the NHS during their time in the UK. There will also be no routes for self-employed persons coming into the UK, and prospective candidates under a skilled worker visa will need to be paid under PAYE. All candidates applying for a skilled worker visa will also need to pass an English language test, and border control will no longer accept ID cards from countries such as France and Italy. This is understood in an attempt to clamp down on non-EU workers beating the system with forged or stolen ID cards. As you can note as well, that there is a tradable points for salary, and we can see that obviously that we have also a number of different categories. So category A, the minimum salary would either need to be $25,600 or the going rate according to their standard occupational codes of practice for that role. We then have category B, which is obviously with respect to a relevant PhD. So obviously if a client has completed a PhD in a subject relevant to their job, and the applicant's salary would need to either be at $23,040 per year or 90% of the going rate for their role. If the candidate has a PhD in a STEM subject, i.e. science, technology, engineering or mathematics, and it's relevant to the job that they're doing, the salary can be £20,480 per year and or £80% of the going rate for their role, whichever is the higher. If the role falls within a shortage occupation list, then obviously the salary again would be $20,480 as a minimum, or 80% of the going rate for their role, whichever is higher. And then category E looks at new entrants. So if the candidate is a new entrant, i.e. either a student who is switching to a skilled worker visa or a candidate who is under the age of 26, then obviously salary can be $20,480 per year and or 70% of the going rate for their role, whichever is the higher. And then lastly, we have those who are in category F, which is roles that fall within the health and within the health and education SOCs. And in that respect, obviously, the salary would either need to be at a minimum 20,480 or 80% of the going rate for their SOC. Now, in terms of obviously the English language requirements, there is also a requirement for EU and non-EA nationals to satisfy an English language test. This can be satisfied by either passing an approved English language test, which is a Home Office recognised English language test, or they have taken a bachelor's degree level or above and has been taught in English, and we've also obtained a UK NARIC, or what is called now an ECCTIS recognition for their qualification. There is also an exemption if they're a national majority English-speaking country, where they can simply rely on their passports as proof that they can speak English to a sufficient level. Now, what does this mean for you? Well, time is finance. Your business clients need to take appropriate steps to plan for and support their workforce now. Again, employers HR must be in place to allow you to direct foreign talent workforce after the 31st December 2020, and your clients may need to apply for a sponsor license to be an approved employer. You may need to contact your clients in order to action this. Finally, you and your client's HR needs to be up to speed with legal requirements, including appropriate skill level jobs, English language requirements, minimum salary qualifications, family members, and the application process. Let's now obviously move on to right to work checks. So obviously, again, with changes to EU and non-EU nationals, there will be more of a relevance in terms of right to work checks and making sure that you have done this properly. So what is a procedure for right to work checks after the 30th of June 2021, following the end of the transitional period for EU nationals? Who do these checks apply to? So this is obviously really specifically for anyone that is physically working in the UK. And again, what's the sanctions for illegal working, and what's the repercussions? So right to work checks. All employers in the UK have a responsibility to prevent illegal working. You can do this by conducting right to work checks before you employ someone to ensure the individual is not disqualified from carrying out the work in question by reason of their immigration status. If you conduct the check as set out in the Code of Practice, you will have a statutory excuse against liability for a civil penalty in the event you are found to have employed someone who is prevented from working due to their immigration status. If the Home Office do find out that you've employed someone who does not have the right to work, but you as the employer conduct the right to work check as required, your organisation will not incur a penalty for that illegal worker. One important thing is that obviously that you will not be deemed to have a statutory excuse if the check has been performed by a third party such as a recruitment agency. So it's important to make sure that you as an employer also conduct a right to work check, as well as obviously any recruitment agencies that may have performed such a check prior to placing that candidate with them. So who does this right to work check apply to? Well, the right to work check should be carried out by employers who employ staff under either a contract of employment, service or apprenticeship, whether express or implied, and whether oral or in writing. So how can EEA citizens prove their rights to work from the 1st of July 2021? Well, prior to July 2021, the Home Office had a transitional measure which allowed employers to continue to accept either their passports or national ID cards, and there was a duty not to discriminate against obviously EA nationals until the 30th of June 2021. So we couldn't really demand that that EU nationals provide their EU settled status or pre-settled status. Post the 1st of July 2021, the only acceptable right to work check for EA nationals will be an employer share code. So employers can still use the Home Office online right to work check service to prove their right to work. EA citizens must provide their share code and their date of birth, which will enable employers to check their Home Office immigration status via online service. And an EA citizen with settled status will have a continuous right to work in the same way as someone with indefinite leave to enter or remain status. An EA citizen with pre-settled status will have a time-limited right to work, and employers must carry out a follow-up check. The Home Office will advise when a follow-up check must be carried out. Now, changes to the right to work checks for EA and Swiss citizens from the 1st of July. So you can, as I said earlier, you can no longer rely on an EA passport or national identity card to provide their right to work. Instead, EU nationals will need to provide you with an employer share code, which you will then need to verify in order to confirm they have a right to work. There is no mandatory requirement for retrospective checks to be undertaken on EA nationals who are employed on or before the 30th of June 2021. However, it's best practice to have a record of your workers' profile as at 30th of June 2021. Now, what's the sanctions against illegal working? Well, if you're found to be employing someone illegally and you fail to carry out the prescribed checks, you may face the following sanctions: either a civil penalty of up to £20,000 per illegal worker, a prison sentence for up to 5 years and an unlimited fine, closure of the business and disqualification as a director, not being able to sponsor migrants, and seizure of earnings made a result of illegal working. So it is important that you get this right. Who and when? So who do you conduct a right to work check on? Well, it is advisable to carry out right to work checks before you employ a person to ensure that they're legally allowed to do the work in question for you. If an individual's work is time limited, you should conduct a follow-up check shortly before it is due to come to an end. And there are two types of right to work checks: a manual check and an online check. Both will provide you with a statutory excuse. So let's look at obviously manual right to work checks. So there are three basic steps to conducting a manual right to work check, which needs to be conducted before employment commences to ensure you've conducted the prescribed check fully. So step one is that you must obtain original versions of one or more acceptable documents from either List A or List B of acceptable documents. So List A contains a range of documents that you may accept for a person who has a permanent right to work in the UK. And if you conduct the right to work checks correctly before the employment begins, you will establish a continuous statutory excuse for the duration of the person's employment with you. You do not have to conduct any further checks on that individual. List B contains a range of documents you may accept for a person who has a temporary right to work in the UK. And if you conduct the right to work correctly, you will establish a time-limited statutory excuse, and you'll be required to conduct a follow-up check in order to retain your statutory excuse. You must also check the document's validity in the presence of the holder. When you are checking the validity of the documents, you should ensure that you are doing this in the presence of the holder, and this can be a physical presence in person or through a live video link. In both cases, you must be in physical possession of the original document. Therefore, you may not rely on inspection of the document via a live video link or by checking a faxed or scanned copy of the document. The responsibility of checking the document is yours, and you cannot delegate this responsibility to a third party. In order to establish a statutory excuse, you're required only to conduct an examination of the document and to check this against the holder of that document. You can also download apps which enable you to check the authenticity of documents. You can compare identity and travel documents against the images published on, for example, Prado or Edison TD, and following this, obviously, you should make and retain a clear copy and record the date the check was made. This may be either by making a data declaration on the document or by holding a separate record securely, which may be shown to the Home Office upon request to establish a statutory excuse. You may face a civil penalty if you do not record the date on which the check was performed, and simply writing a date on the copy document itself does not in itself confirm that this is the actual date when the check was undertaken. On a manual or digital, so alternatively, a manual or digital record may be made at the time you conduct the copy and copy the document which includes this information. It is advisable that you keep these copies easily available to you in the event that you're requested to show this evidence to the Home Office, and all copies of documents should be taken should be kept securely for the duration of the employer's employment, and for 2 years after afterwards the copy must be securely destroyed, and then for 2 years afterwards, following which obviously the copy must be securely destroyed. It is advisable to use the right to work checklist to ensure that you've carried out all of the steps you need. Alternatively, you use the online tool check if someone can work in the UK, which will take you through the process by asking you a series of questions. Both will help to confirm that you've undertaken each step correctly to establish your statutory excuse. Let's obviously then move on to online right to work checks. So the link obviously that you need to follow in order to complete a right to work check is highlighted within this. And it will not be possible to conduct an online right to work check in all circumstances, as not all individuals will have an immigration status that can be checked online. The right to work checking service sets out what information you will need. So currently the online checking service supports checks in respect of those who hold either a biometric resident permit, a biometric resident card, or status issued under the EU settlement scheme, where obviously these individuals continue to, will be able to obviously provide either their share code, which obviously you will then log in and view. Also, you can obviously look at status documents issued under the points-based immigration status system, or British national overseas B&O visas, or frontier worker permit. If an individual does not wish to demonstrate their right to work using the online service, even if their immigration status or document is compatible with the service, you should conduct the manual check. Let's have a look at obviously what the online right to work check will reveal. So again, obviously you should check that photographs on the online right to work check is of the individual presenting themselves to work. And here is an example of an online check response. So you would then obviously need to retain a clear copy of the response provided by the online right to work check. And this should be the profile page confirming the individual's right to work. And this page includes the individual's photo and the date on which the check was conducted. You will also be given the option of printing the file or saving as a PDF, and this should be secure. This should be kept securely in either hard copy or electronically for the duration of the employment and for 2 years afterwards. Okay. Now, how does the right to work check service work? Well, the service works on the basis of the individual first viewing their Home Office right to work record. They may then share this information with you by providing you with a share code, which when entered alongside with the individual's date of birth, enables you to access this information. The share code will be valid for 30 days, and it's vital that you access the service using the employer part of the service in order to attain your statutory excuse. The Home Office has an audit record of online checks conducted by employers using this service, so it is important to make sure that you use the employer section of the right to work checks for online checks. And what to do if you're unable to do a manual or online check? Well, in this respect, you'll need to contact the Home Office's employer checking service to establish a statutory excuse. And these are situations where, for example, you may be presented with a certificate of application, which is less than 6 months old and indicates that work is permitted, or you consider that you've not been provided with any acceptable documents, but the person presents other information that they've been a long-term resident of the United Kingdom who arrived in the UK before 1988, and you will then only establish a statutory excuse only if you're issued with a positive verification notice from the Home Office. Now, what to do in situations where employees' visas have expired? So if on the date in which your employee's visa expires, you're reasonably satisfied that your employee has submitted an in-time application to the Home Office to extend or vary their permission to be in the UK, or is unable to provide acceptable documentation or presents other information indicating they've been that they're a non-EA long-term lawful resident of the UK who arrived before the 1988, your statutory excuse will continue from the date of expiry of your employee's permission for a further period of up to 28 days to enable you to obtain a positive verification from the employer's checking service. Now, this grace period does not apply to checks carried out before employment commences, so in such circumstances you should delay employing the individual until you receive the positive verification notice from the employer checking service. Now, we've got here obviously the Home Office contact details here as well. So obviously if you need to contact the employer inquiry helpline for information about employing workers, there is the telephone number there. And obviously the lines will be open from Monday to Thursday, 9 a.m. to 4:45 p.m. and Fridays from 9 a.m. to 4:30 p.m. Now, obviously, again, obviously, there are often going to be cases where obviously you may receive false documentation or you have doubts as to whether a genuine documentation belongs to the candidate. This is likely to increase more and more requirements, obviously, to conduct right to work checks, and you should use the link. You should use the link to report the individual to the Home Office or call the employer helpline on 0300 790 6268 in order to obviously to ask them to verify the candidate's documents that have been provided. So that's all from me. Now, obviously, I pass over to Dan and invite any questions, obviously, in terms of any changes in the immigration rules that you may have some questions on.
Lovely. Thank you very much, Dipesh. I'm going to just revert back to my screen. And yes, we do have several questions that have come in. And if we don't have the opportunity to cover these in the remaining 20 minutes or so, then Dipesh has kindly offered to be on the LinkedIn forum for 24 hours to answer any questions. But I'm going to start with some of the questions that are coming into the chat right now. So you might have covered this, but we've got a question around the right to work record. So this is from Michaela. If someone leaves the company, how long must you hold on to the right to work record in line with GDPR?
Well, okay, so the requirements from the Home Office are that you should hold on to those records for 2 years afterwards.
Right.
And so that's and following that, obviously, in line with GDPR, obviously those documents would need to be secured.
Lovely. Okay, thank you. We've got a question from Justina about the right to work checks amended procedure. Remote video checks conducted due to COVID. Would they continue post 31st of August?
Okay, so I mean, obviously the Home Office have, I mean, again, this is, I guess, a bit of a loaded question because obviously I think it depends in terms of obviously how things progress. But obviously the Home Office have obviously introduced a transitional measure. The notion here is that obviously it will end on the 31st of August, but obviously, and the Home Office are very keen for it to return back to the normal process. But I think, to be honest, I think it's one of those that where we'll have to wait and see as things develop further.
Okay, thank you. We have one question here from Sylvia. Thank you. In relation to the B1 English standard, there are various tests being promoted. What are the recognised equivalents to the B1 test standard? Is there a list of these? Also, for jobs that are not on the skilled but are critical, what standard of English is required? For example, key positions in production, manufacturing, they may be semi-skilled roles, but not linked to recognised educational qualifications. Is the English requirement different subject to the job role?
So unfortunately not, and again, obviously the Home Office haven't drawn any differentiation between obviously skilled workers and shortage occupationalists. So the requirements are still the same for both for both skilled and shortage occupations. The Home Office obviously do have a list of sort of providers that will obviously that are approved, and obviously, and I think there's a list of sort of obviously 4 or 5 providers, such as language cert, PTE, Pearson, and IELTS that will be acceptable. One of the things that obviously that people will need to make sure of is obviously that they take the specific for UK beyond. So a lot of these obviously providers will provide obviously different ranges of tests, but there is a specific UK VI test that they must sit.
Okay, thank you. I've also got one here from a company involved with research. Xanthi, her name is. Thank you for this question. She said, now we have to submit share codes and give our employer name every time a non-UK person joins us, even when we apparently have no sponsor requirements. For example, when they have a graduate route visa, what are we supposed to do when they leave to make sure Home Office doesn't think we still have them?
So just to clarify, obviously, so they, just in terms of obviously they've recruited the candidates obviously work for them, they've taken the right to work checks. Sorry, can I just clarify, Dan, is that in terms obviously once the candidate leaves their employment, or?
Yes.
Well, again, obviously it's the same process. They will just obviously need to make sure they retain those records for 2 years after their employment comes to an end.
Okay, thank you. Another question here from Lars. Thank you very much. Prior to COVID and Brexit, we had Belgian and French first, second year marketing students work in our office as part of their studies for a 2 to 3 months unpaid internship. Are we allowed to do this going forward?
Okay, so this is where I think there's going to be real issues, because obviously as a French or EA national now entering the UK post Brexit or post the 1st of January, they will only be entering the UK as a visitor. Now, the visit visa rules do not permit obviously them to undertake paid employment and also obviously to provide voluntary services. So this is obviously something that is going to be quite difficult obviously for them to come in unless obviously they consider sponsoring them under a visa.
Okay, lovely, thank you. We have a question from Charlotte, who works for Clyde & Co. In the early careers team. Thank you for joining us and for your question, Charlotte. She looks after the current and future trainee solicitors. So currently, individuals coming through the standard LPC route have challenges securing a student Tier 4 visa unless the course is at a master's level. She's keen to know how this landscape is changing in light of the SQE, if at all. Will students coming in on the SQE route still need to complete a master's level of this in order to secure a Tier 4 student visa?
Right, okay. Just on that, so obviously, so just for me to confirm, obviously, the route is that obviously that that these candidates will come in, complete obviously a GDL course, and as I understand, obviously the GDL or the LPC now has a master's top-up. In that respect, obviously, I don't see much changing in terms, obviously, the requirements for the Tier 4 students. It will more or less continue in the same way as it is right now. The Home Office have sort of obviously, in essence, really sort of obviously just made changes to a number of categories where they, where essentially the same rules apply to non-EA nationals, and they've just simply extended that to include obviously EA nationals. So there have been a number of categories which have just simply sort of obviously extended over to EA nationals as well as non-EA nationals. I hope that answers the question, obviously, but again, obviously, there is also now routes in terms, obviously, for legal associates to qualify under obviously skilled worker visas. So again, paralegals can now qualify under skilled worker visas to for their trainee contracts and things like that. And again, obviously, a little bit lower salary requirements than obviously than what was previously for the category for solicitors. So I'm hoping that's obviously answers, but again, if she has any further questions, I'm happy to obviously to explore that further with her.
Lovely, thank you, Dipesh. Another question. I'm interested to know whether there are any further updates on the end of the temporary right to work checks where we could verify this online. I have it that it ends on the 31st of August, which I think you mentioned, and then it reverts back to face-to-face right-to-work checks. So it'd be great to know if this is still the case or whether it's been extended.
So again, I think that just points back to the earlier question, and where obviously I think it's one
Yeah.
of those where we will have to obviously wait and see. The temporary measures obviously were initially due to come to an end, so obviously in June, July. And as obviously the pandemic's obviously continued, that was extended until the 31st of August. I think it's one of those where obviously it depends on obviously on country situation. Hopefully, obviously it, as we move obviously to obviously easing restrictions, obviously that I think it will go back to obviously manual checks and then online checks in that sense.
Okay.
Again, obviously I think that because with the introduction of e-visas, so obviously and actually just one of the points that I think we should probably obviously just talk about is obviously that there are a lot of obviously EU nationals or family members of EU nationals who have a valid BRP card, but that obviously goes post post the 30th of June. And I think there was obviously a few questions that we've had where can you continue to accept them? So if a person has a valid EA card, biometric card under the EU provisions, as a family member, they can continue to accept them until 2022. Following that, obviously the Home Office will gradually move them over to an e-visa. And the notion is obviously that obviously there will be more e-visas issued, and therefore obviously online checks will become a little bit more predominant, and a little bit easier for employers to verify in that sense.
Yeah. Okay, thank you for that. I hope that's answered your question. Another question here from Debbie. We hire in EMEA with branches in the UK, Germany, Sweden, Finland, and Spain. We do visa sponsorship to help with the hires now, especially after Brexit. My question is around changes to immigration laws. Because they're a remote first company, it's her understanding they still need a legal entity in the place our people are located. Europeans can't just work from anywhere, for example, Poland, and can be paid through our German or Spanish entity. Is that correct?
So, I mean, this is actually quite relevant because obviously, especially over COVID, where people have been working remotely, and
Yeah.
we've had staff that have been working overseas, and so in terms obviously for the immigration requirements, it's really where the person is physically based.
Right.
They can obviously, we have plenty of scenarios where we have UK-based companies that employ contractors that are physically working and located in the EU. In those circumstances, it really there's two things. One is that ensure that the candidate has the right to work in the country in which they're located. If they are employed, for example, through the UK entity, they will still then be liable to pay national insurance and income tax. But again, the candidate would also would probably advise that they take tax advice in the country in which they're resident, because obviously there could be some tax implications in that sense. So those are really considerations which I think again an accountant or payroll would look at. Because again, obviously there are implications in the sense of taxation in the country where they're working, and and also for the UK company to pay their income tax and national insurance in the UK.
Great, very helpful. Yes, lots of implications there of remote working and where your actual staff are based. That's very important. And we've had a lot of similar questions around that subject, so hopefully that's helped. A question here from Sylvia. Is where workers who travel and meet the requirements for entry wish to travel with their family, what right to travel do the family members have? Does the job offer cover the family members' right to travel and reside in the UK?
Yes. So if a person was to qualify for a skilled worker visa, then certainly they'd be able to bring in their spouse and any children under the age of 18. Their dependents would be granted leave in line with the skilled worker visa. And actually, interestingly enough, the PBS dependents have a little bit more freedom than the skilled worker, in the sense that they can work for any employer without without the need for sponsorship. They can be paid at any salary level, of course, in compliance with national minimum wage, and they can also be self-employed. They also have a requirement for the spouse of the skilled worker visa holder to be in the UK for up to 180 days if they want to qualify for permanent right to reside after a 5-year period.
Perfect. Lovely answer. Thank you, Dipesh. Question here from Nicola. When you sponsor staff, should you give them a permanent contract or a fixed term based on the length of the sponsorship license?
I mean, there's no right and wrong on that. I mean, obviously, I think that if you're employing someone, so obviously, and you view them as a permanent employee, then you can issue them with a permanent contract. The skilled worker visa does provide a route to permanent residency. So again, it's a long-term obviously visa option. If you're considering employing someone for a short period of time, so obviously maybe for a year, then it will probably be in those cases quite sensible to issue a fixed term contract for a year. So I think it's an individual basis in terms of, obviously, if it's a long-term hire, then obviously yes, a fixed term, obviously a permanent contract. If it's a short term or a 1 year or a 2-year contract, then yes, a fixed term contract would be applicable.
Lovely. I hope that's answered your question, Nicola. Over to Laura now. Thank you for your question. We carry the online check with the share code, but we don't need to ask for the passport at any point or keep a copy of the passport in our files.
That's correct. Well, so that's correct. So obviously the rules have changed post the 1st of July 2021, so that obviously that now you would only accept the share code as part. I mean, just to kind of explain the background on that, when the applicant would have applied, they would have obviously completed a verification check on their passport, which would have read the NFC chip on their passport, and they would have verified everything on that. So it's a bit more of a secure check that the Home Office obviously now conduct, and what you will now need to do is obviously log in through the employer section of the online check. The Home Office, and it's quite important that you do that. So see, we've had scenarios where EU nationals have simply printed out the online check and provided that to employers. Now that's unfortunately not good enough to establish a statutory excuse, and the Home Office will do conduct an audit to make sure that employers have logged in through their portion of the online check, and then obviously downloaded the copy of the results. So it's important that employers do follow that process to establish their statutory excuse.
Great, thank you. I hope that's answered your question, Laura. Over to Naomi now. Thank you for your question. Is there anything in relation to hiring interns and visas that we should be aware of? I mean, is it the same process for permanent hires?
Yeah, I mean, unfortunately so. I mean, obviously the way that the Home Office obviously look at this is that, I mean, there's a couple of options. There is an ICT graduate visa that we could potentially look at, obviously, if they're coming in to for training. But in terms of the skilled worker visa, one of the abilities of the certificate when you assign a certificate of sponsorship is that obviously you put a start and end date into the certificate. So again, obviously, if you're looking at someone for a short term, you can assign the certificate for a 3-month or a 6-month period. If you're looking at someone for a longer term, then obviously you would do a 3-year visa for them.
Okay, thank you very much. I hope that's answered your question, Naomi. Over to Romy now. Is there still a requirement to advertise a vacancy for a specific amount of time before offering to a candidate that requires sponsorship?
So no, this is one of the key changes that the Home Office made, and actually quite a welcome change. So the Home Office have removed what was previously called the resident labour market test, which meant that you had to advertise on Government Find a Job Service and obviously one other recruitment agency for a 28-day period. And obviously, and often this was quite obviously tedious for employers because I mean, I guess obviously the way that you recruit has changed, and obviously, and the chance of getting a very high skilled sort of candidate from the government find a job service is used to be quite minimal. So the Home Office have removed that criteria. However,
Right.
there is a requirement for you to still evidence that's a genuine vacancy. And often we've seen cases where the Home Office have requested further information before approving a certificate of sponsorship to a candidate.
Lovely. Thank you very much. Yeah, I remember that used to be the case for a long time,
Yeah,
but
yeah.
yeah, it's obviously very time consuming and could put off a lot of employers trying to start the process. So that's interesting to know it's now been updated. Hopefully that's answered your question, Romy. Over to Kieran now. Could you explain the process of the 2-year extension for graduates finishing uni?
Yeah, so I mean, obviously, so this is a category that was just recently introduced by the Home Office, and it requires, and it's basically essentially a replica of the post-study work visa that used to exist within the immigration rules. So candidates, obviously, who have completed a degree in the UK, obviously, will be able to apply for this new graduate visa. It allows candidates to obviously to be granted a 2-year visa and allows them to work in any occupation in any role, and obviously, and again, salary levels obviously would just need to be at national minimum wage. The notion is really obviously to allow candidates to build up the necessary experience, to then move forward to apply for the skilled worker visa.
Lovely, thank you. I think you covered this question before, but this person's just joined us, and they're keen to know about recording the date documentation, how it's checked. Could you kindly confirm the procedure, please?
Yeah, sure. Yeah, no. So, I mean, obviously, if you're doing
Thank
a
you.
manual right to work check, then it's worth obviously just simply writing on there. There's obviously specific guidance that obviously that you write, but just saying that obviously that I have certified and I've received the documents, and obviously putting the time and the date on there, and retaining a copy of that document. Again, obviously, where you are doing the online checks, obviously that will be that will have the date on there and when you conduct the right to work check. But where you're doing the manual check, obviously it's important to write on the document that I've now conducted this check on certain date, and time and date stamp that basically.
Wonderful, thank you. I'm just conscious of time. We do have quite a few other questions, and as I say, Dipesh will be on the LinkedIn forum, and maybe in confidence, if you'd like to send a message to Dipesh, if that's okay, he will be happy to deal with that. So we'll just deal with one further
Yeah.
question, just further to the family member piece that you explained earlier. Is there a requirement for the family member to pass the B1, etc., in order to work for other employers where their spouse is on a sponsored job? So if a worker travels, has the job offer, meets the requirements, do the family members apply for right to reside and work in the UK? And what are the requirements on those workers?
Okay, so if they are a family member of a skilled worker, then obviously then they won't need to meet the English language requirements in order
Right.
to apply. However, obviously when they come to apply for their indefinite leave to remain after a 5-year period, that's the only point that they will need to meet an English language requirement. But they don't need this to obviously to evidence to employers or for their initial visa application.
Lovely. Thank you very much. We've got time. I'm going to squeeze one more because you really answered that really succinctly. Um, one from Zara. Can an employee now switch from an ICT to skilled worker visa, and what are the requirements?
Yeah, so I mean, obviously, this is a really welcome change. So previously, obviously, with ICT workers, there was a cooling off period if they wanted to change to a skilled worker visa. So they had a 12-month cooling off period if they were to switch.
Right.
And the only exceptions to this previously is if they fell into the high earner category. The rule changes with effect from January allow the ICT visa applicants to switch from within the UK to a skilled worker visa. Really, obviously, the only major requirements would be that obviously that they would need to meet an English language test, and would need to be assigned a certificate of sponsorship and then make a skilled worker application. But it's a really welcome change. Again, obviously, some employers obviously look at it a bit negatively because an ICT worker can simply come into the UK and then work for another employer, and and it kind of defeats the object. But obviously, it's a welcome change.
Good, thank you. Okay, so as I said, this has been recorded, so the slides will be made available in a PDF format via the LinkedIn forum as well, because there's lots of detail that I'm sure you'd like to go back through. And I'd like to thank Dipesh for covering what is a huge subject in a very short space of time. And we wanted to make sure you got the most important bits and you had the opportunity to ask any questions. So thank you very much for presenting. We do appreciate your time.
No, thank you. Thank you.
And it's great to have such a well-attended webinar today. The next event is on Wednesday, the 8th of September. We're currently working through the subject matter, but it will be the same time, 12:30 to 1:30, same format with our speaker and the opportunity to ask any questions. So that's a date you can save, Wednesday, the 8th of September. So thank you again, everyone. Have a great day and see you at our next event.
Thank you.
Thank you very much.